Hello, my name is Clare Ovey. I'm the head of the legal division within the Registry of the European Court of Human Rights that processes cases against the United Kingdom. And I'm going to try to explain to you some procedural aspects about bringing a case to the European Court of Human Rights. Anyone can introduce an application with the court. In the initial stages of an application, there is no requirement that the applicant be legally represented. And although at the stage that a case is communicated to the respondent government, legal aid is available from the Council of Europe. In these initial stages, legal aid is not available, so that you either have to make sure that your client can pay you, or if legal aid is not available within your domestic system, then you're going to be bringing the case initially pro bono. But having said that, it's obviously of great assistance to the applicant and to the court if claims are properly formulated by a lawyer right from the very start. The initial stages are purely in writing. You introduce an application by sending a letter to the court, which should include a short summary of the facts and a short summary of the matters which the applicant wishes to complain about. At that stage, you will be sent an application pack, which will include an application form, a form of authority, which the applicant should fill in to confirm that he wants you to represent him, and a set of barcodes which should be attached to all correspondence to the court. Within 8 weeks of sending that initial letter, you should send the full application accompanied by all copies of all relevant domestic decisions. Now, about 90 to 95% of applications which are lodged with the court are declared inadmissible by the court, and this is partly a reflection of the fact that there is no requirement for legal representation early on. Nonetheless, even cases brought by lawyers are sometimes declared inadmissible, so you should be aware of the admissibility requirements. The first formal admissibility requirement is that the applicant should have exhausted all domestic remedies. This is a reflection of the principle of subsidiarity, which runs right through the Convention. The Convention is supposed to be a last resort, and an applicant should have used all the remedies available within the domestic system before bringing the case to the court. There is a requirement to use all normal effective domestic remedies. This means in a criminal case, if the issue is an issue of fair trial, that the applicant should have pleaded guilty, should have appealed against conviction, and where relevant, depending on your domestic system, should have applied to the Supreme Court or to the Constitutional Court, for example. There is no requirement, however, to exhaust additional remedies. For example, within the UK system, the court does not consider an application to the Supreme Court where there's been no certificate by the Court of Appeal to be an effective remedy, because there's obviously no chances of success. The court does not also, to take the United Kingdom as an example, consider an application to the Criminal Cases Review Commission after the final appeal to the Court of Appeal to be an effective remedy. The next formal requirement under Article 35 is that the application should have been lodged within 6 months of the final decision within the domestic system. So again, you should be aware of additional remedies, for example, an application to the Criminal Cases Review Commission within the UK again, because this type of application does not set the 6 month time limit running again. 6 months runs from the working day following the date on which the applicant discovered the facts in issue, or where he has used domestic remedies, from the date on which he found out about the judgment that's in the final decision. So, for example, where a judgment is delivered orally by a court, if the applicant or his representative were at the hearing, time starts to run from that hearing. The next admissibility criterion is that the application should not be substantially the same as an application which has already been submitted to the court or which has been submitted to another international tribunal. Next, the applicant must be a victim of the matters complained about. This means that, for example, NGOs can't bring cases complaining about legislation within a state generally. The complaint must be brought by someone who has actually been directly affected by the matter in question. Children and other people lacking capacity within the legal system can be represented by someone who is a legal representative or by a parent. And the other requirement of victim status is that you have not had redress within the domestic system for the matter which you're complaining about. Protocol 14 to the Convention added a new admissibility criterion, which is that the applicant must have suffered significant disadvantage and not have his complaint considered by the domestic courts. Now, this is a new admissibility criterion. For the first 2 years of its life, all decisions made under this subsection of Article 35 must be made by a chamber. And so if you look on the court's database, the HUDOC database of decisions, if you just search under no significant disadvantage, you'll be able to see examples of the type of cases in which the court has held that this applies. The two final admissibility criteria which are very relevant to criminal practitioners are that the alleged violation must have been actually committed by an organ of the state. So this means that if your client is concerned about, for example, negligence by his lawyers representing him at trial, this is not normally a matter which he can complain about to the court. But if he is complaining about decisions made by the judges in his case, for example, then he clearly can complain to the court about that. Finally, the matter must be within the scope of the Convention. The court applies a principle we call the fourth instance doctrine. This means that it is not acting as a court of appeal against domestic decisions, and normally the court will not disagree with an assessment of the facts or the evidence made by the domestic courts. So if your client considers that he has been wrongly convicted, for example, this is not really a matter that the court can deal with. Once an application is lodged with the court, a member of the registry will do the initial sifting process and decide whether the case appears to be clearly inadmissible or whether there does appear that there are issues there which the chamber of the court should deal with. If the member of the registry considers that the case is clearly inadmissible, then the case will be allocated to the single judge procedure. A single judge is a judge of the court. All cases are considered by a judge of the court, and he is assisted by a non-judicial rapporteur who is a member of the registry. The single judge will consider whether the formal admissibility criteria have been met, so whether the case is out under 6 months or non-exhaustion, for example, and will also consider whether the case is manifestly ill-founded, so whether there is no clear issue under the Convention there. The applicant or the applicant's representative will be informed if a case is declared inadmissible by a single judge by means of a simple letter which will just say that the judge found that there was no issue arising under the Convention in the case. And there is no appeal against a declaration of inadmissibility by a single judge. If the case appears to be manifestly well-founded, it will usually be sent to a committee of 3 judges. These judges can follow existing clearly established case law by the court and also award damages to applicants where there is a clear breach of the Convention. Where the case does not appear to be manifestly ill-founded but is not following clearly established case law either, it will be allocated to a chamber. Here, a judge will be appointed rapporteur to deal with the case. The member of the registry will draw up a short statement of facts, and the judge will add questions for the parties. The case will then be sent to the respondent government, who will have 16 weeks to submit observations. The applicant will then be sent those observations and be allowed a further 16 weeks to reply, and then the government gets a further round of observations just to comment on the applicant's claims. When the applicant comes to submit his or her observations, it is extremely important, if the applicant wishes to claim costs and expenses under Article 41 of the Convention, that the costs are formulated at this stage and that all relevant documentation, so fee notes, etc., are included with the claim under Article 41. If the claim is not formulated at this stage, then the court will not allow it at a later stage and you won't get paid. Once all the parties' written observations have been submitted, the court will decide whether or not it wants to hold a hearing. The Chamber very, very rarely holds hearings, although hearings are always held before the Grand Chamber. At the time that the application is communicated to the government, the Council of Europe will award legal aid if the applicant's representative applies for it. This is not a huge sum, but it will cover some of, at least, of your costs. And legal aid is available whether or not you win the case, whereas the claim for costs and expenses, as I said, under Article 41 of the Convention, will only be awarded in the event that the applicant proves at least one of his complaints under the Convention. The court does not generally go in for any fact-finding. It is very dependent on the findings of the domestic courts as regards facts, and that is why another reason why it's extremely important to exhaust domestic remedies before you come to the European Court. If a case raises a new issue under the Convention, or if the Chamber, when it comes to decide the case, considers that it would like to break with existing case law, then it must refer the case to the Grand Chamber. If a chamber decides to refer a case, then the parties will be notified, and each party actually gets a right of veto. You can inform the court if you do not consider that the case should be sent to the Grand Chamber at this stage, and ask the chamber to decide it. But if one of the parties does want to exercise this right of veto, it must give reasons for it. The other route to the Grand Chamber is once a chamber has decided a case, the judgment does not become final until 3 months after delivery, and either side can, within that 3-month period, write to the court and ask for the case to be referred to the Grand Chamber. The Grand Chamber, as I said, normally does hold hearings and will also ask for further written observations from the parties. The judgments of the court, so either the Chamber once the 3-month period is expired, or the Grand Chamber once the judgment has been delivered, are final and they're binding on the respondent state concerned. Where the court has found one or more violations, then the case is referred to the Committee of Ministers for enforcement. The Committee of Ministers will ensure that any money which has been awarded by the court to the applicant is paid by the government, and will also consider whether any individual measures or general measures are needed. Individual measures can mean in a criminal case that the case is sent for a retrial. It can mean that the applicant should be released from prison. These are issues which the Committee of Ministers will consider. It can also mean, in terms of general measures, that the Committee of Ministers will recommend to the state concerned that, for example, legislation or national practice should be changed to ensure that similar violations never occur again. I hope that this information has been useful to you. There is more information about bringing an application to the European Court, as I said, on the court's website, and I wish you very good luck if you do decide to bring a case to the court.